Hello, and welcome to California Gun Law. I'm your host, Don Hammond, with an update on the Hoffman v. Bonta case regarding the legal status of non-resident California CCW licenses. There was an injunction battle after the court ruled in favor of gun owners, and that's now been resolved, so we'll take a look at that. Also, I recently argued my first non-resident CCW denial court hearing up in Placer County, so we'll take a look at how that turned out. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms, laws, and regulations, and there are lots of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss legal updates that apply to people who live outside of California and want to get a CCW license that allows them to carry a gun in California. There's been a lot of recent action in the courts on this topic, so let's break it down. Many of these tips also apply to California residents applying for a CCW license. First of all, California offers no reciprocity to any other state's CCW license. So your license from Arizona, Utah, Oregon, etc. will not allow you to carry a gun in California. Hopefully, the federal legislature will give us some relief on that soon, but House Resolution 38 seems to be moving pretty slowly with no progress since March. So what's a traveler to do? You'll need to get a non-resident California CCW license. Sounds simple, right? Well, not really. California's statutory scheme for CCW licenses currently does not have any provision for granting a license to a non-resident. However, in two recent lawsuits, courts have held that California must issue non-resident CCW licenses to members of certain organizations. These organizations include the California Rifle and Pistol Association, Gun Owners of America, Gun Owners of California, the Second Amendment Foundation, and the Firearms Policy Coalition. The decision that added Firearms Policy Coalition was issued on July 1st, 2025 in a case called Hoffman v. Bonta. The court asked the DOJ and the FPC to meet and confer to draft an injunction for the court to sign. The parties were unable to agree, surprise, surprise, so they each submitted a version to the court. DOJ's version was over 5 pages of legal hoops for applicants to jump through, while FPC's version is a simple 1-paragraph court order. The judge adopted FPC's 1-paragraph version of the injunction, holding that Attorney General Bonta and his cronies are permanently enjoined from enforcing California Penal Code Sections 26150A3 and 26155A3 as to CCW applicants who are members of Plaintiff Firearm Policy Coalition who are not residents of California. The court signed that injunction on August 21st, 2025, just a few days ago. So for now, step 1 for a non-resident applicant is to join one of these organizations. I agree that should not be necessary, and soon it probably won't be. Some issuing agencies may already not be enforcing the agency membership requirement, but we can't count on that. Assembly Bill 1078 is still working its way through the legislature. AB 1078 is a mixed bag of good and bad things for gun owners, but it will create a statutory framework for issuing non-resident California CCW licenses, and it will not require any association memberships. The new provisions are likely to take effect on January 1st, 2026. Step 2 is to figure out where you should apply. A previous injunction from CRPA versus LASD and the language that the DOJ wanted in Hoffman would require people to apply in the jurisdiction where they plan to visit within the next 12 months. That language is not included in the Hoffman injunction, but AB 1078 will require you to attest under oath that the jurisdiction in which you have applied is the primary location in California where you intend to travel or spend time. There's no time constraint in the proposed statutory language. In most California counties, the county sheriff's department handles all CCW applications. Some counties, however, such as Los Angeles, delegate that duty to local police departments. A Google search for X city CCW license should yield a pretty good result for where to apply. Many issuing agencies use online systems to accept and manage applications, and some still take paper applications. So be sure to pay attention to the requirements of the issuing agency where you plan to apply. It is very important that you fully disclose everything on your application. It's a good idea to pull your own live scan prior to filling out the application so you do not make any errors or forget to include something. It can be a crime to omit information, and it will almost certainly lead to denial of the license application. You don't want to have to go through a whole hearing process just because you forgot to include some old arrest that you forgot about. And under AB 1078, there will be language in the law that prohibits the agency from issuing the application if there's false or misleading information provided on the application. So you don't want to have that fight. Otherwise, the disqualifying factors are listed in California Penal Code Section 26202. They include recent restraining orders. That language will be updated a bit in AB 1078 too. But they also include certain criminal charges and being currently addicted to drugs or alcohol. The most general and subjective reason for denial is that you're reasonably likely to be a danger to yourself, others, or the community at large. I haven't really seen agencies abusing that standard, so you should be okay if none of the enumerated disqualifiers in 26202 apply to you. As a part of AB 1078, the list will expand to include out-of-state equivalents to the current list of California charges and restraining orders, but it will also clarify that a temporary restraining order issued without notice in a hearing is not disqualifying. That'll help several of my clients. You may want to consider altering your travel plans so you can apply at a particularly favorable agency as long as the requirement to attest that you're going to visit that jurisdiction soon still applies. Some agencies issue CCW licenses relatively quickly, and others take a very long time. Different agencies have different application fees, so you might want to look into that. Some require a psychological evaluation, and others don't. You have the option to select where you plan to travel to in California, so you might as well apply at a more friendly agency. Do a bit of internet research to figure out the best place to apply out of the destinations that are on your California itinerary. The issuing agency will do a background check. They'll require you to take a 16-hour training class and qualify at the range with each gun that you want to list on your license. They will also interview you, call 3 references, and search for available information about you online. So consider what's on your social media profiles. If all goes smoothly, and it should as long as you honestly answer all of the questions and you're not prohibited from having a firearm, your California CCW license application should be granted. If your application is denied, you can request a hearing under Penal Code Section 26206. I have another video about that process, but I've won about 70% of those that I've done for clients. And I just conducted my first CCW denial hearing for a non-resident. So let's talk about that. The case was up in Placer County. My client lives in Virginia. The prosecutor argued that he was not even entitled to a hearing under Penal Code Section 26206 because the statute requires that he request a hearing in the county where he resides. I pointed out to the judge the absurdity of requesting a hearing in Virginia and argued that due process and equal protection require the court to exercise jurisdiction in the county where he applied. just as the CRPA versus LASD and the Hoffman v. Bonta cases require the agency to process his non-resident CCW license application. The Placer County Sheriff's Department denied my client because on his application he failed to disclose a court-martial case from when he was in the military. He was found not guilty in that case and later honorably discharged, so he didn't think that he needed to reveal it. Since then, he's been working in executive protection and holds CCW licenses in multiple other states. I argued that the court-martial case does not make him a disqualified person, failure to disclose is not a legal reason for denial under current law, and that the court should exercise its discretion under Penal Code Section 26202A to overturn the denial. The court took the matter under submission, and we just received the written ruling in the mail, holding that the hearing process does apply to a non-resident applicant, and the court agreed to exercise its discretion to find that my client was entitled to a CCW license in the county of Placer. So that's a big win, using brand new cases to fight for a non-resident applicant. I'm happy to report that these cases are having a boots-on-the-ground influence and that out-of-state residents are in fact getting licenses, and if they're not, we're able to win in court. I'd love to hear about your experiences with applying from out of state. Where are you from? Which California agency did you apply with? How was the process? Let us know in the comments. Hopefully this information will help others decide where in California they want to visit, and hence where they will need to apply for a non-resident CCW license. Feel free to head over to cagun.law, check out our merchandise, and latest updates on cases. I'm Don Hammond at California Gun Law. We'll catch you all next time. Stay informed, stay legal, stay safe.